All right, so we are here tonight to talk about the Michigan medical marijuana laws. This, as you can see on the map, is a map of the state of Michigan as of sometime in 2017, showing how not the state of Michigan, the entire country, including the state of Michigan, showing how the states have sort of come out on the medical marijuana and recreational marijuana issue at this time. If you can't read it, the green states have made it legal for adult use or some sort of recreational type of use. The red states have made it still, that it's still illegal to possess or use medical marijuana or any type of marijuana or cannabis. The tan and beige states allow limited uses. For example, some types of CBD oils that have low THC levels. And the yellow states are the states in which medical use is allowed. But before we get into the current state of the law, I want to sort of take you through a timeline and a little walk through history. How did we get here? We got here a long time ago, and we'll talk about pre-1970, but the very first Federal Controlled Substances Act was in 1970 when marijuana became listed as what's called a Schedule I drug, and we'll talk about what that means in a couple of minutes. But that's sort of the beginning, and then we fast forward through time to talk about November of 2008 when most people remember here in Michigan the Medical Marijuana Compassionate Care Initiative, which was Proposal 1 at the time, was approved by 63% of the vote. The legislature enacted it shortly thereafter, and in the spring of 2009, the state put out the administrative rules that are to govern certain procedures and policies under the Compassionate Care or Medical Marijuana Act, the MMMA, as some people know it. Summer of 2009, the state started getting all kinds of applications for caregivers and patients. We'll talk about what that means. September of 2016, we fast forward about 8 years, about 7 years, from the time that the applications came in, and the legislature has moved us forward into what is now known as the Medical Facilities Licensing Act, or the MMFLA. And then in December of 2017, last year, the state opened up the doors, or the gates, for commercial facilities license applications under that act. So that's an overview of the timeline that we're now going to walk through. So going back to 1970 and before, in America at least, this used to be at least some of the campaign against marijuana. And for those who can't read it, these types of cards and literature were distributed saying, "Beware, young and old, people in all walks of life." This, and then it has a photo of a marijuana cigarette, may be handed you by the friendly stranger. It contains the killer drug marijuana, a powerful narcotic in which lurks murder, insanity, and death. And then there are warnings about dope peddlers and how shrewd they are, and they may even put it in your tea or in your tobacco cigarette to get you hooked. I think, as we all can see, we've come a long way since then. So a lot of people ask me this question. I thought it important to talk about tonight. Why is it spelled funny? Everyone asks me, why does it have an H in it? Why isn't it marijuana with a J? And the answer to that is that, as best I can tell from my research, and I'm sure others have looked into it on their own, back in 1898, we were involved in what was known as the Spanish-American War. A little bit of history there for you. And the Spanish-American War created a lot of American resentment toward Mexicans and Mexican immigrants. So the spelling with an H was decided upon by anti-drug officials in the United States so that they could turn people off to smoking pot by, according to Martin Lee in his book Smoke Signals in 2013, exploiting prejudice against despised minority groups, especially Mexican immigrants. The H spelling ended up being the version that was used in the Marijuana Tax Act of 1937, and again in the Controlled Substances Act decades later. The H spelling, though, started phasing out in the 60s, as with a lot of trends and fads. Experts aren't sure why, but one theory is that more Americans caught on to the pronunciation of Spanish words by the 1960s, so the J in marijuana became more commonplace. And today, as we evolve even farther beyond the 60s, the term marijuana is actually starting to fall out of grace. Drug advocates and researchers that are trying to go back in time, they're trying to go back to before all of the loaded words were used and just use the non-loaded word cannabis. Just a little piece of trivia for you to take home with you. That J spelling that you do know and appreciate, that is uniquely American. Even Canada still spells it with an H. There are other theories, of course, as to why we use the word marijuana as we do. There's the Oxford English Dictionary speculates that maybe it comes from the Nahuatl malhiwan, which means prisoner. There are some linguists, however, who just differ with that. They don't think there's any semantic basis to connect it to marijuana. They think it's just accidental that they're so similar, because cannabis is not known to have been present in the Americas before Spanish contact, which makes an indigenous word an unlikely source. Other suggestions are tracing the possible origins of the word to the Chinese ma ren hua, which is the hemp seed flower. There's also a Semitic root, MRJ, that is found in the Spanish word mejorana, and in English marjoram, which is oregano, which could be related to the word marijuana, and this is also known in Mexico as Chinese oregano. And of course we have some folk etymology. Obviously we know about the Tom Petty song, Mary Jane, and the personal name Maria Juana may have been part of the origin for the name we use today. Some history, the word entered English usage in the late 19th century. According to the Oxford English Dictionary, the first known appearance of a form of the word in English was in Hubert Howe Bancroft's 1873 book called The Native Races of the Pacific States of North America. Other early variants include marijuana in 1894, marihuma, first recorded in 1905, marihuano in 1912, and marijuana in 1914. So this little chart just kind of gives you some more of the history lesson in terms of when the word marijuana sort of came into use with the J. You can see in blue, we have the word cannabis was typically the term used back in 1860 and moving forward. And then right around 1930-something, we see the J spelling, but we also see the H spelling. The H spelling peaked in the 60s and has now started to fall out of favor as we use the J in America. But for some reason, it remains in our state and federal laws. Now, a lot of people also ask me the question, why don't we just decriminalize it as a country? Why, as a country, do we still insist on keeping it as a crime? And a lot of people don't realize that when the country makes decisions on something like this, they're also dealing with international politics. And we have international treaties in place that actually address marijuana and other types of narcotic drugs. In fact, we have the single Convention on Narcotic Drugs from 1961. It has 186 countries who are parties to that. And that convention, that treaty, makes it a Schedule 4 drug, different terminology than we use in Michigan. But under Schedule 4, that is the most strictly controlled category of drugs internationally. And the single convention only, or specifically excludes medicinal drug use from prohibition if the parties, on their own, decide to limit it exclusively to medical and scientific purposes. And they're talking about, when they talk about medical and scientific purposes, the production, manufacture, export, import, distribution of, trade in, use, and possession of these drugs, these Schedule 4 drugs under the convention. Therefore, I think the important point to take from this is because cannabis restrictions are embedded in the text of the single convention, complete legalization would require denunciation of that treaty, amendment of the treaty, or a reinterpretation of its provisions that would likely be opposed by the International Narcotics Control Board. So there are politics at play when we talk about going nationally to a legalized form or use of marijuana. So bringing us forward to today, the current law in Michigan is that it is still a Schedule 1, the most strictly controlled drug in Michigan, under the Michigan Public Health Code. The Michigan Board of Pharmacy makes it a Schedule 1 drug if the board finds that the substance has high potential for abuse and has no accepted medical use in treatment in the United States or lacks accepted safety for use in treatment under medical supervision. There's an important word in there that lawyers will catch more than most, the word or. You know, our English teachers taught us about ors and ands, right, and the difference that they make when we're reading a sentence. The word or is important because even if most people agree that there is some accepted medical use in treatment, and I know people still differ on that, but even if we did agree, the or clause kicks in, lacks accepted safety for use in treatment under medical supervision. So essentially what they're saying in that quote is until we have procedures and rules in place for safe use as a medical treatment under medical supervision, it remains in Schedule 1 and can't be relocated. So moving us forward out of the fact that that law is still the law, it is still a Schedule I illegal substance to possess and use, 2008 comes around and the voters approve the Medical Marijuana Act, as it's known, the MMMA. The law required the state to implement rules within 120 days, and on April 4th, 2009, they did adopt rules that would implement the law. The law has two basic components to it. You can be a qualifying patient. That's a person who has been diagnosed by a physician as having a debilitating medical condition. Debilitating conditions, as you can see from the list on the screen, include cancer, glaucoma, AIDS, hepatitis C, Alzheimer's. But it can also include symptoms from a chronic illness, such as severe and chronic pain, severe nausea, seizures, muscle spasms. And according to the state, its 2016 annual report, we don't have the 2017 report yet, 98.86% of all of those who got a patient card from the state under the new act had severe and chronic pain and muscle spasms as their reason for needing the card. 3.81% had cancer listed, and 1.74% had epilepsy listed. Mark and I both attended a seminar a couple of weeks ago in Dearborn, and Lieutenant Kip Belcher of the Michigan State Police quoted to us that according to the state of Michigan, only 5% of all of the patients who are registered have what they would term a serious medical condition. So that would leave symptoms and other chronic types of pain as the non-serious things that people are using the patient cards for. Under the Medical Marijuana Act, a patient could designate a caregiver if the patient so choose, and would indicate whether the patient or the caregiver would have permission to possess marijuana for the patient to use as for a medical purpose. Each patient can only have one caregiver, and each caregiver can only have 5 patients. Very important rule there. The statute or the voter initiative only allows people who act as caregivers to service 5 people who are linked to them in the state system, meaning they cannot service or provide marijuana in any medical form for any medical purpose or otherwise to anyone they are not linked to under the current law. The current law also talks about the plants that are allowed. Michigan does not limit the size or distinguish between seedlings versus mature plants. So under the act, a caregiver can cultivate 12 marijuana plants per patient for up to 5 people. So if you do the math, that's 60, and if they themselves are a patient, that's 72 plants. 72 plants can grow very, very tall, taller than me for certain. There is no restriction in the act. They can grow them as big and as full as they choose, as long as they stick to the limit of 72. And 12 plants alone for one person can yield quite a bit of marijuana. The annual yield of a 12-plant indoor marijuana grow site would generate between 44 and 72 ounces of marijuana. And Lieutenant Belcher, during his presentation a couple of weeks ago, gave us sort of some numbers that the state police look at. He said if you sell top quality marijuana for $3,000 a pound, which is essentially $3,000 per plant every 90 days, that works out to $864,000 a year if a caregiver is not obeying the law and is actually selling all of that marijuana at top quality prices to any buyer that might want to take it. So how does the Medical Marijuana Act work? Persons with the condition, they have to get a certificate from a physician. It's not a prescription. A lot of people use the words wrong. It's not a prescription from a doctor. It's just a certificate certifying that they are likely to receive palliative benefits from marijuana. They file an application with the state. They pay the fee. They file the physician's certificate, and there's a 2-year registry created for those people. Caregivers can assist up to 5 people, and they cannot have any felony drug convictions in order to be caregivers. The registry is confidential because of HIPAA laws. If you don't know what HIPAA stands for, it's the Health Insurance Portability and Accountability Act. It's a federal act that protects all of us and our medical and personal information when we receive medical treatment from providers. So because it's confidential, it is not subject to Freedom of Information Act disclosure, and it cannot be given to law enforcement. So police officers are only allowed to confirm valid registry numbers if they are presented with a medical marijuana card. That can sometimes be a frustration for police officers working with the city. We certainly have talked to many about their frustration with understanding more about the underlying background behind the card, but they're only allowed to know that it is in the system and it's a valid card. Local officials cannot disclose the information. It would be a misdemeanor for them to do that. So therefore, it becomes a complication for us to even know as a city where it is being grown, and it complicates our ability to do inspections or even have disclosures of home occupations. So that's the Medical Marijuana Act. That's the one the voters approved. Now we fast forward 8 years later. And 8 years later, the Michigan legislature and the state governor created and enacted the Medical Marijuana Facilities Licensing Act. This came into effect at the end of 2016 with an effective date of December of 2017 to begin working through it. The act creates a 5-member licensing board appointed by the governor, and it has certain requirements and criteria for who's to sit on that board, and a marijuana advisory panel that is supposed to consist of 17 people. We do have the 17 names if anybody's interested. And if you get a license, you get immunity for possessing, growing, purchasing, testing, infusing, extracting, altering, receiving, selling, transporting, transferring, manufacturing, and buying from a provisioning center, so long as you do so within the limits of the Medical Marijuana Act. In other words, the first law that the voters approved, if you stick to the limits, which is the amount of usable marijuana you're allowed to possess and have at any given time and purchase at any given time, then you have immunity for buying it, and the provisioning center has immunity for selling it, and everybody in the process has immunity for being part of the process. So who's in the process? The Medical Marijuana Facilities Act, our new law that we're here to talk about tonight, created 5 categories of marijuana businesses, medical marijuana businesses that are going to be allowed in the state of Michigan as of December of 2017. They're still doing the application process. Mark's going to talk more about that as we go forward. So nobody actually has a Michigan license yet, but there are communities that are opting in, and we'll talk about that, to allow all different kinds of licenses, one or more of them, the first of which is the grower. Everybody knows and everybody understands medical marijuana is grown by somebody. So in order to do it legally in Michigan, other than under the old act, which still exists, still is around, still is legal for you to be a patient or a caregiver and do it, but if you want to do it in a commercial way of some kind, you don't want to be limited to just 5 people that you can provide medical marijuana for, you need a grower license to provide that to somebody who is then going to sell it later. The growers grow the raw product. They sell seeds or plants to a grower, another grower. If another grower wants to get started, they can buy from a current grower. They can sell marijuana to a processor or provisioning center, and they are only allowed under the statute in industrial or agricultural or unzoned areas. Sterling Heights doesn't have any unzoned areas, so it would be an industrial or agricultural area were it to be allowed in the city. Most, if not all, transfers of marijuana will have to be by a secure transporter, although in January, as of January 30th, they updated the law to create a couple of minor exceptions for transferring medical marijuana for certain proximity situations where you're just so close to each other there's no point to needing a secure transporter to deliver it from one to the other. Under the Act, an active employee is required who has 2 years' experience as a registered primary caregiver. It's an interesting nuance of the new law. So in order to be a grower, to have a grower license, you must hire somebody who's been doing this for 2 years under Michigan law as a caregiver. So it's intended, I think, to provide experience to the business so that a business doesn't start fresh without understanding how to be a primary caregiver or how to grow marijuana for people as a medical use. But at the same time, the law also prohibits growers from actually being a registered primary caregiver or employing anybody who is. So it's encouraging caregivers under the Act from 2008 to become growers with a license, but get out of the caregiver business, get out of doing it on the side and do it as a licensed commercial entity. The new law says that there are 5 levels of growers. You can have a Class A, B, or C license, depending on what the community that you're in allows you to do, if they decide to allow any at all. 500 or 1,000 or 1,500 plants are the different levels. So that's growers. So after they make the product, they grow the product, someone has to test the product under the statute. So safety compliance facilities is the fancy term for the testers. They are going to perform tests on marijuana, and they're going to return it then to either whoever sent it to them for testing or to another marijuana facility to move it on for either processing or otherwise. We'll talk about those in a minute. The safety compliance facilities are the only licensed facilities of the 5 that do not have to be a Michigan-only entity. The others require a Michigan entity be the applicant, someone who's been here for a period of time. They're supposed to be given a head start, but this one does not. Possibly they had the foresight to think that maybe there aren't that many in Michigan that could do it, It's unclear to me why, but for whatever reason, there is no Michigan-only requirement to be a safety compliance facility and to apply for that now. The safety compliance facilities have to be accredited by an entity that's approved by the board 1 year after the date the license is issued, or they have to have previously provided drug testing services to Michigan or the Michigan court system and be a vendor in good standing. So that's part of the application process to vet the types of applicants that come through for this kind of a license. And they're required to perform their testing under very certain scientific standards. That'll be, I think, more established as the state continues to make administrative rules for us, including testing for chemical residues such as fungicides and insecticides, determination of THC and CBD levels, testing for microbial and mycotoxin contents, and testing for compliance with other good manufacturing practices that are established by the state's rules. They are required by the law as well to retain and employ at least one staff member with a relevant advanced degree in medical or laboratory science. So we have growers and we have those who test the grown product. We also have what are known as processors. The new law provides that processors are designed to package the product. They may only take possession of marijuana and transfer it by a secure transporter. We'll talk about what that is in a minute. They can only sell marijuana and marijuana-infused products to a provisioning center. So the processor packages it up for retail sale, basically, if you want to keep it simple. Their job is to put the labels on, to put the required warning labels or testing information on the package, and then give it to the provisioning center who will sell it. This is the provisioning center clause. So the fourth type of license you can get under the Michigan Medical Marijuana Facilities Licensing Act is a provisioning center license, otherwise known as a dispensary. That's how the public understands them, but the term provisioning center was used in the new law to explain the type of business that can sell or transfer marijuana to a patient or to a caregiver. So it isn't a true dispensary in the sense that anybody can walk in and buy their products. You must be a patient or a caregiver under Michigan law, the Michigan Medical Marijuana Act that we talked about at the beginning, and as long as you're in the system and you stick to the rules as far as how much you can buy or have, you're allowed to purchase it from this type of organization now as opposed to somebody on the side or on the street. They must transfer their marijuana to or from a safety compliance facility for testing. They may only purchase from a grower or a processor. They may only sell to a patient or a caregiver. No sale or transfer to a patient or caregiver until marijuana has been tested will be allowed, and it must be labeled as required for retail sale by the state of Michigan. They have to check the statewide system every time they have a transaction to make sure the registry card is valid, and they have to verify that the sale or transfer is within the daily purchasing limits that are going to be set by the board. There is to be no sale, consumption, or use of alcohol or tobacco products on the premises, and they are not allowed to offer medical examinations or certifications on the premises for people to then obtain a registry card on the spot. Not included in the definition of a provisioning center, a non-commercial location used by a primary caregiver to assist a qualifying patient. So taking us full circle back to the very first law we talked about, the one approved by the voters, the Michigan Medical Marijuana Act. If you are not a commercial enterprise, you are just a primary caregiver assisting your 5 patients or less, you are not a provisioning center, and you do not need to have a commercial license to do what you do. And that takes us finally to the one I've alluded to, the one that sort of makes this all go, the secure transporter. The 5th type of license that the new law allows and requires is the type of license that allows someone to move the products between the other 4 facilities. They can store, they can transport marijuana and money that's associated with the purchase or sale of marijuana between the various facilities. They can charge their fees for doing that. They may not transport anything to a patient or a caregiver directly, though. That's, again, to be done through the provisioning center. Each driver has to have a chauffeur's license. Each employee has to be free of felonies or controlled substance misdemeanor convictions for 5 years. Each vehicle has to be operated by a 2-person crew with 1 person staying with the vehicle at all times. A route plan and manifest must be in the system. A copy must be in the vehicle and must be provided to police upon request. Marijuana has to be in sealed containers. It cannot be accessible during transit. And the transporting vehicle may not indicate anywhere on it that it is carrying marijuana or a marijuana-infused product, and all of these vehicles will be subject to inspection by police at any time during transport. For a while, and the last time I gave this presentation, there was an interesting nuance in the law that said that a grower could only transfer marijuana by using a secure transporter, as of January 30th, I alluded to it earlier, a transfer of marijuana to a provisioning center from a marijuana facility that occupies the same location as the provisioning center does not require a secure transporter if the marijuana is transferred to the provisioning center using only private property. So in other words, if you have a provisioning center set up on the same exact parcel or parking lot of a parcel or a strip mall or a center like that, that doesn't require you to go out on the road to get to the next licensed facility, you don't need a secure transporter. It's only for if you're transferring or transporting on public roadways. So in order for all of these new laws to work, the state also had to amend the original law we talked about, the Michigan Medical Marijuana Act, to add a new definition for marijuana-infused products and a new definition and a new formula for what's a usable marijuana equivalent. These new definitions do apply retroactively. They clarify the quantities and forms of marijuana for which a person is protected. The new law also establishes rules for transporting marijuana-infused products in a motor vehicle, and most important for local communities, it prohibits the use of butane extraction in a residential structure, residential curtilage as well, or any public place, in order to separate plant resin from a marijuana plant, or in any manner that demonstrates a failure to exercise reasonable care or reckless disregard for the safety of others. So when they put this law together, they had obviously heard from local communities that butane extraction is dangerous, things can blow up. We don't want to allow that in residential or in any way that is in disregard for the safety of others. The state has established a tracking system. They call it a seed-to-sale tracking process. This is the technology that they'll be using if anybody wants to look at it for themselves. It's on YouTube. That's where this comes from. Just go to YouTube and type in the Michigan statewide monitoring system, or you can type in metric training, METRC training. METRC is the name of the software product that the state has decided to use to track all seeds all the way up to sale and keep it in the system so that the state can monitor where medical marijuana is coming from and going to. The licensing process for all of these businesses, the first day of applications was December 15th of 2017. Background checks are required for all employees. Licenses are not transferable unless the board approves. All licenses must be renewed annually, and even though we talked about the fact that there are only 5 categories of license, there are actually 7 types of license, because remember, growers can have one of 3 different types. So I'm pretty sure that makes everything clear for everybody. But just in case it doesn't, these are some of the more common questions that I think people have. Can any of these facilities open up in Sterling Heights? The answer to that is no, not unless the city actually adopts an ordinance that allows one or more of these facilities to exist. Who can obtain a license for these facilities? Only a commercial entity, and the major stakeholders must be Michigan residents for at least 2 years by June 30th of 2018. What criteria will the state be applying to any applicants for a license? As you can see on the slide, they cannot employ a caregiver. We talked about that. There can't be any felony convictions or incarcerations during the last 10 years. No controlled substance or moral turpitude misdemeanor convictions in the last 5 years. The board is going to create a number of additional criteria, and licenses are renewable annually. The city and its residents can provide input to the board, and the board must consider that input when deciding on licensing. Can a license holder have more than one type of license? Very common question. In some cases, no. The statute was pretty clear about that there are some that just have too much of a conflict of interest to be the same license holder. A grower, processor, and provisioning center cannot have an interest in a safety compliance facility or a transporter, and those two cannot have any interest in any other type of facility. A few more questions we hear a lot. Can these facilities be monitored by law enforcement? Absolutely yes. The law allows inspections by state and local police at any time. Will the products be tracked? Yes. As we talked about, the law requires that all marijuana from seed to sale must be part of that statewide tracking system that you saw on the screen. Can these facilities be located together? Yes, they can. The state currently plans to allow co-location of growers, processors, and/or provisioning centers. That doesn't mean the city or any other community has to allow that. It just means that the state is willing to allow that. Can a growing facility ever have more than 1,500 plants? The answer to that is yes and no. The state is going to allow growers to stack multiple licenses at the same location, but they have to be tracked and identified separately. Again, cities and local communities do not have to allow that. That is something the state is allowing. We think more because some of the rural communities, specifically up north, North Michigan, have a lot of space, and the space would be wasted if they were limited to 1,500 plants. Can caregivers continue to grow at home? The answer to that, again, is yes and no. A person has to give up their caregiver status to be part of a growing facility or a secure transporter, but a caregiver can also choose to just remain a caregiver. So that's the law as it exists today in Michigan and a little bit of history lesson. From here, I'm going to turn it over to my colleague, Mark Kaszubski, and Mark is going to try to take all that information for you and tell you what it all means, not only for the city of Sterling Heights, but for Michigan and all of our communities. Mark?
Thank you, Don. Well, now that we have a good primer on what these facilities are, what the state requires, and how this legislation came into being, one of the questions that we have to ask is, who is this helping and where are these people at, and how are they helped by these acts? Well, to get a handle on that and what is going on in both the state and in Macomb County, we have to kind of look at the numbers. So in 2017, as you can see, we have a chart of medical marijuana card holders for patients that was listed by MLive. So Macomb County was listed as 52nd out of 83 counties tracked for the number of patients per 1,000 residents. By comparison, Wayne County is 59th and Oakland County was 61st. Believe it or not, Montmorency County, just below the tip there, the darkest red, they're 45.1 patients per 1,000 residents. Ottawa County was the lowest at 11.8 for what that matters. As of January of 2017, about 2.2% of Macomb County residents were found to have patient medical marijuana cards. So that's about 20,000 residents in Macomb County. So looking at more numbers, you can see what is the statewide trend is that medical marijuana caregivers and medical marijuana patients are increasing. So the statewide amount of patient card holders in 2014, as you can see, jumped by over 85,000 to 2015 to 182,091 statewide. From 2015 to 16, that number jumped again, 36,465 patients. Last November, on November 20th, the Detroit News reported that the number of patients with medical marijuana cards had gone up by, again, 53,659. And that number is expected again to increase through 2018. So still more numbers if you look at this and kind of dig down deeper. Although we don't have a complete breakdown of the statistics for last year with respect to the counties, I can tell you that 2016 statistics were as follows. Macomb had about 19,455 patients and about 3,304 caregivers, whereas Oakland had 24,414 and around 3,960 or so caregivers instead of patients, sorry. These numbers have increased since that time, and again, what we know as of November 20th through reporting, that the number of caregivers statewide has risen to approximately 43,266, which constitutes about a 12% increase in the amount of caregivers since last year, in 2017. The number of patients increased to 272,215 patients, which is about a 20% increase. So what you're seeing is the trend is continuing to go up, as you might imagine. Again, going back a little further, just looking at Macomb County's history in particular, you see MLive's chart in 2012, from 2012 to 2016. What we can say is, assuming that the 20% increase in card holders holds true, we can guesstimate that Macomb County has approximately now 23,500 or so card holders. To put that into perspective, from a population standpoint, there are 27 municipalities in Macomb County, made up of around 841,000 people. So again, that number comes out to about 2.7% of the county has medical marijuana patient cards. Assuming that that percentage holds true for Sterling Heights, which is what we would want to look to, you would say that out of our 140 or so thousand residents, that about 4,000 or so have medical marijuana patient cards, roughly around the 2.7%. And showing how this number kind of goes through, if you look at the state of Michigan, the next census will likely show that we have around 10 million residents altogether, and with 272,000 card holders, again, it puts us back at 2.7%. So it kind of does flow across the board for us as to what that percentage is for the for this caregiver and patient model to date. So when the act comes in, the next question is, who's in and who's out? As Don indicated, to allow facilities in your community, you need to opt in or opt out through an ordinance process. So what are other communities doing? And this is an important question because, for example, if you allow a provisioning center in your municipality and the neighboring municipality doesn't, will the other neighboring municipalities' patients then come to your municipality to purchase, or vice versa? If you don't allow that and somebody else does, will your residents be going somewhere else? So these are some concerns the city would have to deal with. So who's in? Well, what we know is there's about 33 or so that have opted in affirmatively through ordinances. The closest to us being the city of Detroit, Hazel Park, River Rouge. You can add Harrison Township to that mix as they've recently adopted their ordinance. They're allowing everything but a provisioning center. And who's next? So there's about 27 communities that I've researched that are currently in the process of writing an ordinance to opt in. And again, the bolded ones are within 50 miles, but some important ones include the city of Lansing, Ann Arbor, Gaylord, Saginaw. So some of the major cities in our state are going to be opting in. Who's out? Well, there's a total of 80 or so that have declared permanently that they will not be having, at least permanently for now, if that is a word, that they will not be allowing these facilities to be in their municipalities. And that includes Troy, Livonia, Fenton Township, Shelby Township, Oak Park, Lincoln Park, Commerce Township, Richmond, Grand Blanc. We also believe that most of the northern Macomb County communities really have no interest in opting in at this time, but they have not come out and said one way or the other. So taking the snapshot in time, right now there's 533 incorporated municipalities in Michigan. Only about 60 of them have opted in or are working towards it. By contrast, 80 or more communities are believed to have opted out. Of those 30 that are drafting their ordinances now, we don't know what they're going to do, if they're going to allow all or some or multiple licenses for the various licenses that are available. The larger communities, Detroit, Ann Arbor, Kalamazoo, Flint, they're in. So, you know, we are seeing a good cross-section of what's going on here. It's kind of even, but the big point here is nearly 360 municipalities right now are either studying the issue like we are, or have chosen to do nothing, or are simply waiting to see how the industry develops. Those are pretty much the current numbers, so you see what's going on. What's the reality? Reality is, communities are not really rushing into this. Some are, but the vast majority haven't. Again, there's no timeline to opt in for a municipality, so most municipalities can take their time and look at this issue and study it before making their decisions. And that means Sterling Heights, for example, has the ability to proceed cautiously in this regard, like any other municipality. So this is my soapbox moment. Actually, I think the sign should say 3,300 days since the MMMA came into play. I'm not a big fan of home grows that are happening around the city. I don't think that the MMFLA is going to have any significant impact to remove home grows. The reason I say that is because it's very difficult to get licenses for the MMFLA, and there's a good likelihood that home grows will continue to supply demand, even though not technically legally, by selling to individuals or out of state or other areas. From my perspective, I think what you have to understand, and is important to understand, is the home grows don't go away under the MMFLA. Don already alluded to this, that the MMA is still going to be there. They're still going to have the patient-caregiver model, and that creates a draw for patients one direction, while the MMFLA is going to create a draw for patients the other direction. One is highly restricted, is going to be highly monitored. It does add legitimacy to the sale, whereas the home grows are going to continue to operate. So we're fighting that battle, and the state's going to have to do something at some point. Right now, they haven't done anything except get rid of butane in the homes, which is a good step, but not nearly far enough. So, as with any law and what you would expect, one of the questions the city has to also consider is what's the cost versus the benefit of this. So, from a financial standpoint, the benefit is increased revenue in the form of fees, taxes, revenue sharing, etc., while the financial cost will be found in increased police, regulatory inspections, and nuisance complaints and abatements, things of that nature. So what is that financial benefit? Well, to do that, we have to kind of talk a little bit macro and then get down to the micro. So on the macro, we're talking about how much money is this industry really developing? Well, the estimates are by 2025 that the medical marijuana market projections for both medical or recreational is going to be upwards of 22 to 24 million or billion dollars, excuse me, in the marketplace. So what does that mean for Michigan? In Michigan, it's anticipated that the numbers, if the industry gets up and running fully, that'll generate about $750 million per year in revenue when it's fully implemented. Some estimates state that if this were to go recreational in Michigan, that that market could exceed $1.5 billion in revenues with a B. So what does that mean? Well, now we got to drill it down to the city level. So as it sits right now, if, let's assume for 2019, some facilities have gotten licensed and there's some revenue being generated and the yearly revenue is about $250 million. Now that's an estimate that I heard from the state police. So as we talked about with Don, the MMFLA creates what's called an excise fund where 3% of that revenue is going to be put into an excise fund that is ultimately gets distributed amongst municipalities and various policing organizations and things of that nature. For the city's perspective, they get 25% of that 3%. So 3% off of 250 million is 7.5 million. If you take 25% off of that, it's about 1,875,000. So let's assume for the moment in 2019 there are 500 licensed facilities, which is possible. That would mean that each facility, the dollars that would go to a municipality based on the amount of facilities they have for each facility, it'd be $3,750 to the city for each facility they allowed. So if Sterling Heights had 10 facilities, for example, that would be about $37,750 per facility coming from the state and the revenue sharing through the excise fund. Now, what's interesting is if you double this, if I'm wrong and it's 500 million and it's 1,000 facilities, oddly enough, it's the same number coming back to the city. So the city makes more and there's more financial benefit for the more licenses that they have. That's just how it's going to work. If Pinconning, for example, has allowed 70 some odd licenses for grows, they're going to get, if they open up all 70 of those, they're going to have 70 times 3750. Now, that's because they can do it up there in that rural area for the grows, but you know, that's how you multiply this thing up. Now, what's interesting under this law, which I thought was unique, is that the tax is only on the provisioning center sales. So it's not about the grows or the processing or the compliance or the transport. It's only on the grows, or I mean, only on the provisioning center, excuse me. So that means if Sterling Heights didn't allow a provisioning center, but allowed a transport company, that would be considered a facility which would then get revenue from that excise fund. So it doesn't necessarily mean you have to adopt all. Like Harrison Township, for example, has no provisioning centers allowed. So if they allow 5 of each other licenses and all of them open up, you know, that's going to be a significant amount of money for them without having a provisioning center. Other financial considerations to think about. All of these sales are subject to the 6% sales tax, which is predicted to eventually, when it's up and running, generate about $4.3 million more for constitutional revenue sharing to municipalities. Additionally, each community is allowed to charge up to a $5,000 licensing fee annually based on actual cost of the city inspection. So it may not be 5,000, maybe 4, depending on what that number would be when the costs are determined. And you can expect some increase in real property for future development if you were to redevelop some distressed properties. What that total amount will be is hard to determine, as we don't have a test sample yet. Literally, nobody has a license in the state yet. So we don't see what the benefits are yet to a community or what those costs are going to be for policing them. Again, whether those revenues will be offset by additional police enforcement, nuisance abatement efforts, that's part of the equation that has to be discussed and thought about. So the next question is, what would it look like? So assuming for the moment that Sterling Heights were to allow something like this to happen, you know, what are the safeguards and protections there? Well, I heard from one lawyer recently that it's harder to get a license here through the state than it is to get access to the White House unfettered. You are literally going through a lot of hoops to get this. So it requires proof of hundreds of thousands of dollars of fixed and liquid assets just to qualify for each of these licenses. You have to disclose all the ownership interests. Wives have to be disclosed if they have ownership interests. Partners, there's no silence here. Everybody would know who is owning this. It requires detailed site planning. All of this has to go to the state before it even talks about what Sterling Heights would require. It should be far greater than this. All of the employers and owners would have criminal background checks. So it requires a significant amount of work. Now I will say this. Right now they are operating under emergency rules. That's one of the things about the act. When it came into place, they were supposed to have created all the rules within a year. And as Lansing is and Lansing does, it takes a while to do that. So instead of doing that, they came out with emergency rules. And those emergency rules aren't very in depth. I mean, they set certain standards, but they don't go very far in what they do. So we can expect that when the new rules come out, there's going to be additional things, and additional considerations, and maybe even trump some of what local municipalities in the area have done with their ordinances. We don't know that yet. The act itself says that you cannot regulate quality and purity, things of that nature, and anything else that is already a law in the state. So if our ordinance were to contradict the state law would preempt. So not knowing what those final rules are is a big issue going forward. So going further, we would look at, the city would have to look at nuisance concerns as a primary concern, location, where these things would go, what type of safety precautions should have to be done. This list is relatively small because if I were to take each one of them and list all of the factors and things we'd have to consider, it would take 3 or 4 pages. And in fact, I had a former slide like that and I got rid of it because you'd never be able to read it. It was so small. So one of the things about local control and regulation that the MMFLA does provide, it does provide some ability for the city or the municipalities that opt in to write ordinances to kind of look and try to come up with processes to have the best possible candidates. For example, we wouldn't want this, any of this. This would be bad, and that would be something that we would never allow to happen. But with that said, you know, there are some examples across the country of decent and maybe even good provisioning centers, or a look at like what vehicles would look like so that they wouldn't have any markings on them, or maybe a testing facility or a complex that's set back a ways and it is kind of innocuous. These are things that are possible. Whether we can get there is another question. Again, you'd want top-notch growing facilities, not the ones that look like they are in somebody's basement. Again, testing facilities would have to be top-notch. Now, some of these facilities like transporting, processing, and testing may have no real outward appearance to the community, while public grow operations and provisioning centers would. So some would be a little more strict than others, depending on what we would be looking at. We don't know. One of the game changers that is coming forward, though, and what we have to talk about is what is going to happen likely in November. The Michigan Marijuana Legislation Initiative will likely appear on the ballot in Michigan in November of 2018. And what this does, it allows adults aged 21 and older to possess and use marijuana for recreational purposes. So if this passes, understanding that this would permit those individuals to also grow 12 marijuana plants in their residences. It would include an excise tax of 10%, which would be levied on marijuana sales. It would allocate revenue to local governments, K-12, and repair, maintenance, and bridges. Problem is we don't know how this is going to impact with the MMFLA. The MMFLA is expandable, but there's no way that's going to be up and running in full capacity come November. So what this is going to do is be a game changer. We don't know what emergency rules will come out. We don't know what laws will be changed. This could change the entire landscape of how this Medical Marijuana Act actually runs. And that is a concern for any municipality looking going forward. With that said, there's really no dispute that statewide there is a demand for this. Your proponents will tell you back in 2008, you know, the act passed at 63% of the voters. I don't know if those voters had the full idea of what the impact would be, but that's how it passed. A recent EPIC MRA survey released on March 5th showed that 61% of Michigan voters would likely approve a ballot proposal to legalize marijuana if it were to occur today. So, oddly enough, though, our community survey through Sterling Heights was 60-40 against. So it does. I guess the question is, where are you asking the question, and who are you asking? Because sometimes statewide, the ballots, the initiatives don't necessarily track with other communities. And looking behind that ballot initiative, it is important to look at the numbers. Really, it's only 45% that are saying they're definitely going to vote yes. 13% stated they probably would vote yes, whereas 3% said they were leaning towards yes. Whereas on the no side, there was 35% saying no, so it was a lot closer if you look at the absolutes. And, 28% said definitely, 6% said probably voting no. So, and there's 4% undecided. So with all of this in mind and what Don had indicated, it's important to get public input on this. I know the City Council has asked for this because it really is going to affect the decision of how we're going to go forward. It does affect our future both socially and economically. So at this point, I'm going to reintroduce Bridget, and I'm going to open this up to questions. If anyone has any questions, comment cards, please hand them to Bridget, and we'll try to answer them for a little while.
I have 4 questions up here, so if anybody else has a question they want to bring up, please bring it up now. And once we complete questions, we will open for public comment. So to begin, our first question, do growers have to package product in a ready-to-sell form to a retailer, or can they sell it in a bulk package?
That's a pretty interesting question. Not something that we would have researched going into it, but I guess I would defer to the state on that and how they're going to allow the process to unfold. Like I said, there's no licenses done yet, and I haven't researched that particular issue. I would assume that a caregiver, I should say a provisioning center, will order product. They'll probably order it in bulk and send it to a compliance and processing facility. And then that would be turned into product, which would then be sold at the provisioning center. So it might be sold in bulk, but it will have to go through the full process of getting processed into the usable marijuana that you would see at the end, sort of the end market for the customer.
Okay, thank you. Question 2. What are your thoughts on the Michigan Zoning Enabling Act provision that characterizes municipal action that has the effect to totally prohibit a permitted use of property as quote-unquote exclusionary zoning?
Well, that's a broad question. I think the answer for our purposes tonight is that provision really has no effect here because the Michigan Medical Marijuana Facilities Licensing Act allows municipalities to say no to any of these 5 uses. Therefore, it would be exclusionarily zoned in a way. But people need to keep in mind that those are very different concepts. What we've got here with the new law is a licensing law. It, as I put up on the slide earlier, it grants immunity to something that is otherwise against the law to do. So if it's against the law to do it and you have an immunity, a privilege, so to speak, just like a driver's license is a privilege, even though everyone can get one, this is a privilege, this is a license, and as a result, it can be denied people because it isn't a lawful use that we have to zone into every community in the state of Michigan.
Thank you. Question 3. Has the city thought about requiring a development agreement? Excise funds are relatively small. The $5,000 fee is nice, but through a development agreement, the city can generate substantial fees. For example, $10 per square foot per year for each type of facility.
I think it's fair to say we have talked about different ways that the city could entertain how to let these types of businesses come into the community, and certainly very strong controls on how to do that. We've seen in other communities, some are doing a lottery system, some are doing a first come, first serve system. I think Mark and I agree, we don't like either one of those because it's just too random. we have talked a little bit amongst ourselves and with the city officials about different ways that we could allow something like this on a very limited basis. One idea would be a special approval land use type of process where we build into our zoning ordinance various specific rules and criteria and various zoning map districts where these kinds of facilities, whether it be one or all five or some combination thereof, could be allowed. We've also talked about an interesting concept that I don't think anybody else has picked up on, the idea of doing requests for proposals. You know, communities often put out requests for vendors who, for example, in Sterling Heights, who wish to be the trash recipient who picks up all of our garbage every day or every week for us. We do it for towing contractors who help the police department and others with accidents on the roadways and removing vehicles that are obstructions. So that kind of an idea, and a request for proposals, would put the creativity in the hands of any applicant to present to the city a very creative or intriguing or incentivizing type of approach that the city could consider and could rate and could certainly prioritize if that was one model that the city were interested in pursuing.
Thank you. Question 4. How can a home grow get insured, and will a home have to be registered?
Well, I guess the first answer there would be to talk to your insurance agent. It's difficult to really give. And first of all, I'm not giving any legal advice today. I will say that I'll take it a different avenue, that landlords have the ability to stop people from home growing. So I guess you have to look at their leases to see if they're allowed to do it. But you know, you're insuring something that is pretty devastating to a home, so I'm not sure what the insurance industry would do.
Thank you. We did have a few more that came up here. Question 5. If a grower must be a caregiver, how come that caregiver can't be a registered caregiver?
Sure. As the question was, how come a grower, a licensed grower, cannot be a caregiver as well under the new law? We don't know the inside workings of the minds of those who wrote it, but it's our belief that the idea was to entice those who are currently caregivers and limited to just helping 5 people out, who maybe want to expand this into helping more people and more at a commercial level. The idea was to entice them out of doing it on the private and doing it in the public eye and doing it in a licensed fashion. So that's our best guess as to why they want you to have 2 years of experience, because they want you to be good at it. But then after that, they want you to get out of it, so you're not doing it in homes, so you're not doing it in retail or tenant spaces or trying to keep it on the sly or surreptitious, and instead you are now in the tracking system and it's all being monitored.
Thank you. 2 more. Hypothetically speaking, if Sterling Heights was to allow provisioning centers, what zoning would be considered? Industrial only, one of the commercial districts, residential buffer consideration, buffer between facilities? These are all questions.
I think from a zoning perspective, we agree that we haven't gotten that far yet. But as you know, the attorneys for the city, we certainly would not let anything get through that would be harmful to our residents or to our existing businesses. The city planner is here tonight as well. If anybody wanted to bounce ideas around with him, I think he's still in the room. But with that being said, it's just too soon to say. I think, especially if you went to a request for proposal type of model, it might be that very limited areas of the city are limited to very specific types of facilities that are going to be licensed, again, assuming the city were even to move forward with opting in. So all of those considerations would be extremely strict, and nothing would be allowed to go through. I speak for myself and Mark, and I'm sure the city planner. We would not recommend anything to the city council that could harm residents or could harm existing businesses.
And similar, the last question is, if the city opted in, what would be the zoning? So I think you kind of just answered.
Pretty much the same question. Yeah, we can't say at this point, but obviously we did talk earlier, the state does restrict growing to industrial or agricultural. So we would not have to allow it anywhere else. And in fact, state law says those are the only 2 zones that growing should take place in.
Thank you very much. We will now move to public comment. If I could just see a quick show of hands for who's interested in coming to the podium today. Okay, looks like a few enough that we'll just allow you the full 5 minutes. So if we want to start in the front, those closest to the stage, and just come up one at a time, and then we'll wrap up once we're through that. Thank you.
Paul Weisberger. Thank you for giving me the time to speak. I think one of the overriding things that I want to make sure that the council member and the mayor and the people that are here tonight remember is that the MMFLA was not designed to enhance and create more marijuana flow in the state of Michigan. That was clearly not the purpose, whether those of you in front of me believe that's going to be the effective case or not. You had a House that pretty much passed all of the bills that we discussed. Great presentation, by the way. About 95% to 5% in favor. And we're talking about a Democratic and Republican House. Then we got over to the grown-ups over in the Senate, and we were able to get 75%, a supermajority, to vote on those same bills as well, which in today's political era is amazing, specifically when we're discussing a controversial subject as marijuana. This wasn't done because they were all rah-rah for more marijuana. It was done because everyone believed, after 3 years of getting bombarded with lobbyists and educated, that there was a major flaw in the Medical Marijuana Act of 2008. There was a massive underground growing operation, a blind pig operation on 8 Mile that was quite impressive, in Lansing, Jackson, Flint, et cetera. It was done as what I would call, to those that are critics, a lesser of two evils. It was done to regulate, control, test, track, tax, and police marijuana in the state. Everyone was pragmatic and realized it wasn't going anywhere. The voters voted and they want it. What I would tell you is I don't see, if every city in this immediate area doesn't take part in the solution, which is to take away the blind pigs, which is to open up an avenue in which you can buy regulated, taxed, child-proof packaged, legitimate high-end product that the patients can use. If you don't make that available, then you're still part of the problem, you're not part of the solution. And my understanding of Sterling Heights is there's quite a robust, growing operation that occurs in a lot of your 1,100 square foot ranch homes. So that's very common in Warren, Oak Park. Insert any city that has cheap rent, 1,000 foot ranch, and you're going to have a growing problem in your basement. So I always say, I have always a neighborhood party where I go to it, and there's always some guy that shows up with some micro brew that he brewed in his bathtub, and he always says, "Hey, Paul, you want to try out my 6-pack?" And I always politely decline. I'd prefer go up to the local liquor store and buy some Pilsner Urquell or some Guinness that I can get right out of the cooler. And I would think that although we have quite a robust caregiver market, because there is quite a robust revenue that can be generated from those that like to serve the blind pigs on 8 Mile, that if we can make it available where we can have it and purchase it from a legitimate, highly accredited provisioning center, and I would strongly suggest to the city of Sterling Heights vet out their applicants, that you do a request for proposal, and that you pick the right applicant, because we are talking about a Schedule I drug in the end of the day. And I respectfully request that you take seriously the idea of adopting an ordinance and opting in. Thanks.
Thank you. And if you could please say your name like this gentleman did, we'd appreciate it. Thank you.
Hello, my name is Mike Elias. That was a great presentation. Basically, I just want to introduce myself. I'm the Chief Operating Officer of Michigan Pure Med, a vertically integrated cannabis operator with extensive commercial experience from Arizona to Ontario. There's two things I want you guys to think about when you're considering going down this path. One, this is a manufacturing process that requires a manufacturing thought in terms of how we approach this. And the other is keeping a patient-centered thought process. I spent 18 years in healthcare. I was a Chief Transformation Officer of North York General Hospital in Toronto. And with all my time spent on the healthcare side, we just can't lose sight of the patient in all this. And there's a few pharmacists in the room. This is a medicinal product that has significant consequences to the patient. And I know we're talking about information at a general level, but I'm hoping that as you go down this path, that we keep that patient in the center of all the discussions. Yeah, that's it. Thank you.
Would anyone else like to make comment at this time? All right, well, I guess that concludes our public forum. I would like to let you know, as you can see, we have cameras here today. This full presentation will be available on the City of Sterling Heights YouTube channel by the end of the week. And if you have any additional questions, please feel free to come to the front and talk to our city attorneys. Thank you very much for being here today.